Hello everyone, my name is Chaitanya Thakur. I am an intern at ubAdvocate under the guidance of Jeevan Prakash sir, advocate on record at Supreme Court of India. Today I want to speak on the topic, the Law of Sedition in India. Every citizen has been granted the freedom to speak and express their views under Article 19(1) of the Indian Constitution. However, this freedom is not absolute and some restrictions have been imposed on this freedom. Like when a person does an act by his words, signs a representation which is held to be contemptuous towards the government, then it is punishable under Section 124 of the Indian Penal Code, which governs sedition. It is an offence which criminalizes speech that is regarded to be disloyal or threatening to the state. This provision, Section 124A, states that whoever by words, either written or spoken, or by signs, or by any visible representation, or otherwise brings or attempts to bring into hatred, contempt, or excites or attempt to excite disaffection towards the government shall be punishable with life imprisonment. Explanation 1 to the section defines the scope of the disaffection, and explanation 2 and 3 defines what under English law is not considered sedition. So there are three elements of sedition. 1. Any words which can be either written or spoken, or signs which can include placards or posters. 2. It must bring hatred, contempt, disaffection against the Indian government. 3. It must result in imminent violence or public disorder. There are other laws in this sedition are also found, such as the Code of Criminal Procedure 1973, the Seditious Meeting Act 1911, and the Unlawful Activities Prevention Act. The constitutionality of this law has been debated in various case laws. First, in Kedarnath Singh versus State of Bihar, it was held that the law is constitutional and covered written or spoken words and had the implicit idea of subverting the government by violent means. With an intention to create public disorder, citizens can criticize the government as long as they are not inciting the people to violence against the government. In the case of Balwant Singh versus State of Punjab, it was held that two individuals casually raising slogans could not be said to be exciting disaffection toward the government. Section 124A would not apply to this circumstance. In the case of Ramesh Thapar of the State of Madras, the petitioner contended before the Supreme Court that the said order of banning his paper Crossroads by the Madras state. It has contravened his fundamental right of freedom to speak and expression. The Supreme Court held that article where the restriction has been imposed is only in cases where the problem to social public security is involved. Supreme Court quashed the order of Madras state and allowed the application of the petitioner. There are some acts which are not considered seditious. First, 1. Improvement or alteration by lawful means, the disapproval of the measures of government. 2. The strong words which are expressing disapprobation of actions of government and not encouraging those feelings to generate public disorder. 3. To improve the conditions of people or to secure the alteration of those acts by lawful means without the feelings of enmity and disloyalty. At last, we can say that sedition is a very serious offence and violation of Article 19. So there is a need that sedition laws should have expressly contained words which satisfy the restrictions of Article 19(2). The purpose of restricting speech under the Sedition Act is the protection of national security. Sedition law should be interpreted and applied accordingly to the guidelines given by the Supreme Court. Thank you.